If you were born on U.S. soil, then you are an American citizen. It's written into the Constitution. It was one of the necessary steps after that little spat called the Civil War. But this might not be the case for long. Yes, incoming President Trump has vowed to end birthright citizenship, and the Supreme Court might let him. But can they do that? For more, we turn to chaos lawyer Liz Dye.
Thanks, Devin. In 1868, Americans amended the Constitution to clarify that anyone born on U.S. soil is automatically a U.S. citizen. What Donald Trump presupposes is, maybe we didn't?
Maybe he didn't?
The once and future president has long promised to end birthright citizenship, most recently in an interview with NBC's Kristen Welker.
You promised to end birthright citizenship on day one. Is that still your plan?
Yeah. If somebody sets a foot, just a foot, 1 foot, you don't need two, on our land, congratulations, you are now a citizen of the United States of America. Yes, we're going to end that because it's ridiculous.
That's... Look, I think he's talking about what was known as the wet foot, dry foot policy under the Cuban Adjustment Act of 1966. That law said that Cuban refugees who made it to American shores were allowed to stay, but migrants interdicted at sea were to be returned to Cuba. Honestly, that has zero to do with birthright citizenship, but okay, since there appears to be some confusion on this topic, let's go back to the beginning. In the beginning, there was racism. Specifically, at its founding, it was legal in roughly half of this country to own other human beings as property. And at the Constitutional Convention of 1787, there was a fight about how to count those enslaved black people for the purpose of congressional apportionment. Slave states wanted to increase their proportional share of the population and thus their number of congressional representatives by counting slaves. Free states wanted not that. And so they passed what became known as the Three-Fifths Compromise. Enslaved people counted as 3/5 of a non-enslaved person for the purposes of the census, and Native Americans were excluded entirely. Now, there were black free persons in America, but in 1856, the Supreme Court ruled in the infamous Dred Scott case that because Scott's ancestors were kidnapped from Africa and sold as slaves, he was not a citizen of the state of Missouri where he lived. 7 years later, President Abraham Lincoln abolished slavery in the United States, and then we had a war, which the Confederacy lost. And that meant that the Three-Fifths Compromise was no longer operable. And so the question became, if you're now 5/5 of a person, does that automatically make you a citizen? After the Civil War, during the period known as Reconstruction, Congress took its first crack at answering that question with the Civil Rights Act of 1866. It said that all persons born in the United States and not subject to any foreign power, excluding Indians not taxed, were hereby declared to be citizens of the United States. And then in 1868, Congress made it part of the Constitution as the 14th Amendment, which reads, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of the citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Freed slaves were, at least on paper, American citizens, equal under the law. Obviously, we've fallen down a lot on those ideals. We're still fighting to ensure racial equality. But as to citizenship, the amendment is unambiguous on its face. If you are born here, you are a U.S. citizen, with two very narrow exceptions, which we will talk about in a sec. But now, let's talk about a case which every law student in America reads in the first 2 months of school. Wong Kim Ark was born in San Francisco in 1873. His parents were Chinese citizens who came to work in America as laborers. In 1889, they went back to China and they took Wong with them. In 1895, Wong attempted to re-enter the United States but was denied admission on the theory that he was not a U.S. citizen. The government argued that even though he was born here, his parents were not Americans when he was born, they were Chinese subjects, which meant that they were not subject to the jurisdiction of the United States under the 14th Amendment. So Wong wasn't an American citizen. And the Supreme Court said no. If you are here and the government can throw you in jail for breaking the law, you are subject to the jurisdiction of the United States. The justices ruled that not subject to jurisdiction described two and only two kinds of people. The first is ambassadors from foreign nations who have what's called diplomatic or consular immunity. They're not fully subject to American laws, and in fact, embassies are treated as functionally foreign territory. So their children don't get U.S. citizenship by virtue of being born here. The other class of people whose children don't get citizenship is soldiers from an enemy army invading the country. So the ruling said, the 14th Amendment affirms the ancient and fundamental rule of citizenship by birth within the territory in the allegiance and under the protection of the country, including all children here born of resident aliens, with the exceptions or qualifications as old as the rule itself of children of foreign sovereigns or their ministers or born in foreign public ships or of enemies within and during a hostile occupation of part of our territory, and with the single additional exception of children of members of the Indian tribes owing direct allegiance to their several tribes. The amendment, in clear words and in manifest intent, includes the children born within the territory of the United States of all other persons of whatever race or color domiciled within the United States. Every citizen or subject of another country, while domiciled here, is within the allegiance and the protection and consequently subject to the jurisdiction of the United States. And incidentally, in 1924, we passed the Indian Citizenship Act confirming that Native Americans were indeed U.S. citizens. The holding in Wong Kim Ark has been good law for 125 years. And the Supreme Court affirmed it again in a 1982 case called Plyler v. Doe. There, Texas wanted to charge tuition to the children of undocumented immigrants who used the public school, and the court said that would violate the Equal Protection Clause. But the court also affirmed the holding of U.S. v. Wong Kim Ark. It said, no plausible distinction with respect to 14th Amendment jurisdiction can be drawn between resident aliens whose entry into the United States was lawful and resident aliens whose entry was unlawful, i.e., undocumented immigrants who are very clearly subject to the jurisdiction of the United States. The court said, those who elect to enter our territory by stealth and in violation of our law should be prepared to bear the consequences, including, but not limited to, deportation. But the children of those illegal entrants are not comparably situated. Even if the state found it expedient to control the conduct of adults by acting against their children, legislation directing the onus of a parent's misconduct against his children does not comport with fundamental conceptions of justice. So it doesn't matter whether the parents are documented or undocumented. You can't punish children for their parents' undocumented status by taking away their education, much less their citizenship. Which sounds pretty fundamentally American, right? Well, not to everyone. On August 12, 2020, a law professor who was little known outside conservative circles penned an opinion piece in Newsweek. He suggested that then-Senator Kamala Harris was ineligible to run for president because her parents were non-U.S. citizens at the time of her birth. His theory was that the holding of Wong Kim Ark was that only the children of lawful permanent residents were entitled to citizenship under the Supreme Court's ruling, as opposed to visiting students or guest workers who intended to return to their home countries. He dismissed the language in the opinion specifically exempting children of consular workers in occupying armies and no one else as mere dicta. Dicta is extra language outside the holding that's not binding precedent, but there's dicta and there's Supreme Court dicta, and generally speaking, if the Supreme Court says it, you treat it as actual law. The professor wrote, were Harris's parents lawful permanent residents at the time of her birth? If so, then under the actual holding of Wong Kim Ark, she should be deemed a citizen at birth, that is, a natural-born citizen, and hence eligible. Or were they instead, as seems to be the case, merely temporary visitors, perhaps on student visas issued pursuant to Section 10115F of Title I of the 1952 Immigration Act? If the latter were indeed the case, then derivatively from her parents, Harris was not subject to the complete jurisdiction of the United States at birth, but instead owed her allegiance to a foreign power or powers, Jamaica in the case of her father and India in the case of her mother, and was therefore not entitled to birthright citizenship under the 14th Amendment as originally understood. The column was widely condemned as racist in an unsubtle echo of the birther conspiracy alleging that Barack Obama, the nation's first black president, was secretly born in Kenya, not Hawaii. Newsweek appended 2 editors' notes apologizing and purporting to be shocked that the piece was being used by some as a tool to perpetuate racism and xenophobia. The author of that article was one John Eastman. Now, Eastman has been a vocal opponent of birthright citizenship for a long time. In 2005, he testified to Congress that Wong Kim Ark was wrongly decided and they should feel free to disregard it. He said, the prospect of potential terrorists coming across our border and giving birth to children once they're here in order to specifically open up a 5th column on our shores is a very real possibility. He also opened his testimony by explaining to the late Congresswoman Sheila Jackson Lee that it was a canard to say that the 3/5 compromise was racist against black people. He insisted that its purpose was to deny additional representation to slave owners. Won't someone think of the poor slaveholders? But Eastman didn't get famous for being a jerk. He got famous in the aftermath of the 2020 election as the intellectual mastermind of the fake electors plot. He was the one who theorized that Mike Pence had the right to reject real electoral certificates representing the accumulated judgment of 20 million voters and instead accept fake ones from the swing states. Well, to be fair, Eastman wasn't the only galaxy brain saying that. He had a lot of help from a Wisconsin lawyer named Ken Chesbrough. And in fact, it wasn't the first time that Eastman and Chesbrough worked together. In 2016, the dynamic duo filed an amicus brief in a Supreme Court petition that involved citizenship of people born in American Samoa. American Samoa is a U.S. territory, and Samoans are U.S. nationals who can travel freely within the United States and don't need authorization to work. But they're not U.S. citizens by birth, meaning they can't vote in U.S. elections or hold federal office. And that continues to be true since the Supreme Court denied review in this case. But Eastman and Chesbrough cooked up an amicus brief on behalf of the Claremont Institute, a major conservative think tank, in which they called birthright citizenship a vestige of feudalism and said it was incompatible with a core premise underlying the American Revolution. Incidentally, that amicus brief was flagged by reporter Josh Kovensky at TPM. Kovensky tracked down Ryan Williams, the head of the Claremont Institute, to ask him how he reconciled the United States being a nation of immigrants, since pretty much everyone who is not Native American is descended from people who came from somewhere else. Williams insisted that we're a nation of settlers more than immigrants. You're kind of saying the quiet part out loud there, dude. Hostility to birthright citizenship is common among Trump's nominees. For instance, Michael Anton, a former speechwriter for Rupert Murdoch, will be the White House Director of Policy Planning. He insists that everyone has simply misunderstood Wong Kim Ark for the past 130 years. He says the court has ruled only that children of legal residents are citizens. That doesn't change the status of children born to people living here illegally, which is clownish and juvenile. But it is coming. So let's talk about what the argument here is likely to be, and then we can talk about the mechanics of implementation.
Now, you've testified repeatedly to this committee that you will uphold the laws of this country and defend the Constitution of the United States. Do you believe birthright citizenship is the law of the land, and will you defend it regardless of a child born in the United States, regardless of their parents' immigration status?
Senator, I will study birthright citizenship. I would love to meet with you regarding birthright citizenship. Can I answer the
serve as the
question?
Attorney General of the United States, and you still need to study the 14th Amendment of the Constitution? That is not.
Domain.com is for the doers. And when you're ready to put your big idea online, this is where it all starts.
Helping me have more confidence in your ability to do this job.
This one's going to involve a little field trip to Texas. Sadly, we will not be stopping for barbecue. Instead, we'll be heading to Eagle Pass, a frequent crossing point for undocumented migrants, where state officials have erected a barrier in the middle of the Rio Grande. USA Today reports that the buoys are connected to form a barricade about 1,000 feet long. They're fastened to the river bottom and have nets below the water to prevent people from swimming beneath them. The buoys themselves rotate so that people can't climb over them. The putative justification for this is that Texas is just trying to protect migrants from crossing there for their safety. The state also blocked migrants from coming ashore by placing rolls of razor wire at the water's edge. You know, for safety. But multiple people have already drowned after getting caught in what is effectively a floating gate. The Biden administration sued to force Texas to get that thing out of the river. The Justice Department argued that the Rio Grande is a navigable body of water, and thus blockading it violates the Rivers and Harbors Act of 1899. Texas countered that the Rio Grande is not navigable, and even if it is, the state is entitled to ignore the border law because it is literally under hostile invasion by undocumented immigrants and asylum seekers. They point to Article 1, Section 10, Clause 3, which bars states from making war or conducting foreign policy unless actually invaded or in such imminent danger as will not admit of delay. Constitutional law professor Steve Vladeck has called this the actual invasion clause, which probably is going to catch on.
Sorry to interrupt, but if you're hell-bent on testing legal loopholes to get around the 14th Amendment or have hired John Eastman, you're going to want a good lawyer instead. But if you want a great lawyer, let my law firm, the Eagle Team, help. If you've gotten in a car crash, suffered a data breach, especially if you got one of those data breach letters saying that your information might have been leaked, or dealing with a workers' comp or social security issue, we can represent you or help find you the right attorney. Because it's so important to talk to a lawyer right away so you can maximize your recovery. And by the way, we don't get paid unless you do, so there's nothing up front. So just click on the link in the description or call the phone number on screen for a free consultation with my team. Because you don't just need a legal team, you need the Eagle Team.
On January 24th of 2024, Texas Governor Greg Abbott announced that he declared an invasion under Article 1, Section 10, Clause 3 to invoke Texas's constitutional authority to defend and protect itself. That authority is the supreme law of the land and supersedes any federal statutes to the contrary. Basically, he says Texas is at war with an occupying army of immigrants, and so he's entitled to ignore all federal laws. The trial court and the three-judge panel of the Fifth Circuit Court of Appeals agreed with the Justice Department that the Rio Grande is a navigable body of water under the Rivers and Harbors Act, and they ruled that illegal immigration does not constitute an invasion. They also rejected the "we are at war" argument. As U.S. District Judge David Ezra wrote, states may not exercise immigration enforcement power except as authorized by the federal government, and surges in immigration do not constitute an invasion within the meaning of the Constitution, nor is Texas engaged in war by enforcing this law. But Texas appealed to the full Fifth Circuit, and sitting en banc, the appeals court reversed itself and held that the Rio Grande is not navigable, so Texas could build that floating wall. The appeals court specifically declined, however, to rule on the issue of whether undocumented migrants constituted an invasion under the actual invasion clause. And that's because there's a strong precedent against issuing constitutional rulings when not necessary to resolve a case. But one particular judge took issue with that. Meet Judge James Ho, who would very much like a spot on the Supreme Court if one opens up. Vox's Ian Millhiser has called Ho the edgelord of the federal judiciary. He writes scathing rulings defending the rights of wife beaters and child abusers to buy guns. He loudly announces that he won't hire law clerks from schools like Columbia University because of the cancel culture and the woke. And he goes out of his way to misgender trans litigants. Now, the first time around, President Trump's red line for Supreme Court justices was abortion. He was never going to appoint anyone to the Supreme Court who was unwilling to overturn Roe v. Wade. But you can only take away women's right to bodily autonomy once, and what Trump wants now is a justice who will greenlight his immigration orders no matter how crazy. But that puts Ho in a little bit of a pickle, because in 2006, Judge Ho, who is, by the way, an immigrant from Taiwan, wrote an article entitled Defining American, Birthright Citizenship, and the Original Understanding of the 14th Amendment. And in that article, he scoffed at the suggestion that there was some kind of magical workaround for the plain language of the 14th Amendment. He said, birthright citizenship is guaranteed by the 14th Amendment. That birthright is protected no less for children of undocumented persons than for descendants of Mayflower passengers. Text, history, judicial precedent, and executive branch interpretation confirm that the citizenship clause reaches most U.S.-born children of aliens, including illegal aliens, which is a little inconvenient for his career ambitions at this point. And so, Judge Ho wrote a concurrence in the Rio Grande Buey case in which he went out of his way to say that undocumented migrants could absolutely be characterized as invaders under the actual invasion clause. And furthermore, he said that a determination by a governor or a president that an invasion was underway was not reviewable by any court. In law speak, that's called a non-justiciable political question. Judge Ho started from the premise that the president's decision to declare immigration was an invasion is clearly unreviewable, and then he said, I see no principled basis for deferring to a president's determination of an invasion, but not to a state's. If anything, the Constitution is more explicit in authorizing the states to engage in war than it is with the president. And in case that was too subtle, after Trump won, Ho sat down with conservative legal scholar Josh Blackman to explain that anyone who reads my prior writings on these topics should see a direct connection between birthright citizenship and invasion.
You're wasting tons of money on deodorant. Stop it! Did you know deodorants don't actually stop sweat? Deodorants use
Birthright citizenship is supported by various Supreme Court opinions, both unanimous and separate opinions involving Justices Scalia, Thomas, Alito, and others. But birthright citizenship obviously doesn't apply in case of war or invasion. No one, to my knowledge, has ever argued that the children of invading aliens are entitled to birthright citizenship. Everyone agrees that birthright citizenship doesn't apply to the children of lawful combatants, and it's hard to see anyone arguing that unlawful combatants should be treated more favorably than lawful combatants. There is not a pick-me-girl in this land who can compete with that man. But in case you got a little lost in the legalese, the state of Texas is floating a theory that undocumented immigrants should be treated as an invading army, and Judge Ho is telling Trump that that would be a terrific way to get around the 14th Amendment. All you have to do is claim that the nation is under attack by terrified people fleeing war and poverty, and then you can magically ignore the Constitution and 130 years of Supreme Court precedent. I feel like we talked about Trump pulling the fire alarm and shouting emergency as a way to get around the fact that the Constitution gives Congress the power to impose tariffs in that video. It's kind of his signature move. So how is this all going to go down? Well, let's ask the man himself.
Joe Biden has launched an illegal foreign invasion of our country, allowing a record number of illegal aliens to storm across our borders. From all over the world they came. Under Biden's current policies, even though these millions of illegal border crossers have entered the country unlawfully, all of their future children will become automatic U.S. citizens. Can you imagine? The United States is among the only countries in the world that says that even if neither parent is a citizen nor even lawfully in the country, their future children are automatic citizens the moment the parents trespass onto our soil. As has been laid out by many scholars, this current policy is based on a historical myth and a willful misinterpretation of the law by the open borders advocates. As part of my plan to secure the border on day one of my new term in office, I will sign an executive order making clear to federal agencies that under the correct interpretation of the law, going forward, the future children of illegal aliens will not receive automatic U.S. citizenship. It's things like this that bring millions of people to our country, and they enter our country illegally. My policy will choke off a major incentive for continued illegal immigration. We will secure our borders and we will restore our sovereignty. Starting on day one, our country will be great again. Our country will be a country again. We'll have borders, we'll have proper education, and we'll put America first.
Okay. That's not a roadmap. It's just a misstatement of the law. But let's assume that Trump actually does intend to do something. That something is likely to be an executive order, either claiming that 130 years of settled law and a constitutional amendment are wrong because subject to the jurisdiction never included undocumented immigrants, or he'll take his cue from Judge Ho and call immigrants an invading army hostily occupying the land. Or He might do both, even though those positions are directly opposed to each other. Whatever the justification, he'll instruct the federal government to refuse to issue the benefits of citizenship to children of undocumented immigrants. So he'll direct the Social Security Administration to refuse to issue Social Security numbers to newborns and tell the State Department to deny passports to the children of undocumented immigrants. And I think it's fair to assume that states like Texas will immediately start issuing non-citizen birth certificates that identify the children of immigrants as not entitled to the benefits of citizenship, all of which will immediately be challenged in court and most likely enjoined until a final adjudication by the Supreme Court itself. And you would think that 130 years of precedent would give us confidence about the outcome at the Supreme Court, but these guys, you never know. And one more thing to flag. Trump is perfectly happy to deport those children who were born here and already granted citizenship when he sends away their immigrant parents.
Let me ask you about another group of people, the estimated 4 million families in America who have mixed immigration status. So I'm talking about parents who might be here illegally, but the kids are here legally. Your borders are
You're talking about separation.
Yeah, well, I mean, there are two aspects to this. Your borders are, Tom Homan said, they can be deported together.
Correct.
Is that the plan?
Well, that way you keep I don't want to be breaking up families, so the only way you don't break up the family is you keep them together and you have to send them all back.
Even kids who are here legally?
Well, what you're going to do if they want to stay with the father? Look, we have to have rules and regulations. You can always find something out like, this doesn't work, that doesn't work. I'll tell you what's going to be horrible. When we take a wonderful young woman who's with a criminal and they show the woman, and she could stay by the law, but they show the woman being taken out, or they want her out, and your cameras are focused on her as she's crying, as she's being taken out of our country, and then the public turns against us. But we have to do our job.
See, the problem is the camera focused on the actual human beings harmed by this policy and not the vicious drumbeat of hate against the most recent wave of people coming to America and trying to build better lives for their families. On the plus side, maybe Trump will get distracted and just wander off like he did last time.
I was going to do it through executive action, but then we had to fix COVID first, to be honest with you.
Sure you were, buddy.
Now, as you probably saw, Trump's vow to end birthright citizenship got a lot of credulous news coverage. It was covered by over 243 news outlets, with most coming from the left or center sources, and about 1/4 coming from the right. But if you compare those headlines, you start to see some interesting frames emerge. On the left, you see headlines like "Experts pour cold water on Trump's plan to end birthright citizenship," or that Trump's take on how citizenship works is utterly absurd. Center sources tend to include "Can he do it?" in their headlines, and focus mostly on the unlikely but not impossible routes for Trump to get what he wants. Then on the right, we see headlines emphasizing that ending birthright citizenship is popular with voters, or that it's a policy backed by the overwhelming majority of American people. Now, depending on which article you see first, your view of the story can be completely different. And that's why I like to see news from as many angles as I can. Now, this analysis is all possible thanks to today's sponsor, Ground News, a website and app developed by a former NASA engineer on a mission to give readers an easy, data-driven, objective way to read the news. And right now they're offering LegalEagle viewers 40% off their unlimited access Vantage subscription. You can scan the QR code or use the link in the description to get a discount for a limited time. What's great about Ground News is it gathers related articles from around the world and across the political spectrum, so you can see the bias and compared coverage. Every story comes with a quick visual breakdown of the political bias, factuality, and ownership of the source's reporting, all backed by ratings from 3 independent news monitoring organizations. One of my favorite parts is their bias comparison feature, which highlights specific differences in reporting across the political spectrum. This can be especially helpful when reading stories from sources you've never heard of, where there's no telling who owns that source or what agenda they might have. And I also love their blind spot feature, which shows you stories that are underreported by either side of the political spectrum. It helps explain why we often talk past each other, and some people seem hyper-focused on what seems like complete nonsense, often because some random blog post went viral among certain groups. But that's why Ground News is my favorite way to get the news. And as a LegalEagle, you can get 40% off the Ground News Vantage subscription by scanning the code on screen or clicking on the link below. This subscription gives you unlimited access to every feature, including the Bias Insight tool, the blind spot feed, and by subscribing, you'll support an independent news platform working to make the media landscape more transparent. So click on the link below or scan the code today. And after that, click on this link